County of San Mateo, Department 210 is now in order. Judge Griner presiding. Please be seated and come to order. Please turn off all cell phones and refrain from talking.
Good afternoon, ladies and gentlemen. People v. Vega has been assigned to this trial board for our purposes. Before we begin, I'd like to have the defense introduce themselves, please.
My name is Grace Bauer, and I will be acting as trial argument for Ms. Vega.
And it's Ms. Bauer.
Yes.
Bauer.
B-O-W. And with the court's permission, we are now please introduce themselves.
Yes, trial attorney.
Good afternoon, Your Honor. Ryan McElroy for Adrian Vega.
Good afternoon, Your Honor. Saloni Gupta for Adrian Vega.
Pronounce the last name.
Gupta.
Thank you.
Good afternoon, Your Honor. Ria Sting for Adrian Vega. And at this time, with the court's permission, our witnesses would like to introduce themselves.
Yes, please.
Your Honor, the court should grant the defense's motion to suppress Adrian Vega's statements after she was in custody and before she was given her Miranda warnings. The government must notify arrested defendants of their Fifth Amendment constitutional right not to incriminate themselves.
Ms. Bauer, you indicated to grant your motion to suppress statements. I heard plural and statements. What exactly are you asking the court to suppress?
I believe all bracketed statements should be suppressed.
All right, since I don't know what bracketed means and the record is not going to know, do you have something verbal that you can tell me what you're asking to be
I
suppressed?
believe Ms. Vega's statements. I didn't know it was a car. I didn't know it was a bicyclist. I'm sorry.
All right, that sentence,
Yes, should be stricken from record.
you may proceed.
The Fifth Amendment, the meaning for Miranda rights became knowledgeable during the 1966 Supreme Court case Miranda versus Arizona, in which the defendant was not informed of their Fifth Amendment constitutional right and was therefore incriminated themselves under unconstitutional circumstances. Similarly to my client, Ms. Vega.
What was the factual setting in the Miranda case of Mr. Miranda when he was being questioned by the police? Can you tell me that?
As far as I know, Miranda was in a police station, in a police-dominated environment, and was not, as I said before, was not informed of his rights.
When you say police-dominated environment, what do you mean?
I mean, I would suggest using the test under U.S. versus Crikey, in which you consider the number of officers present, whether or not the number of officers present, and if they were armed, if the suspect is isolated, if the suspect is restrained, and if the suspect is told that at any time they are free to leave or terminate the interrogation.
And what type of test do I use in this situation to determine whether I should grant your motion?
You should use the U.S. versus Crikey test, which is the police-dominated environment test, and the Thompson versus Kehan test, which is a totality of circumstances, which was also outlined in People versus Herndon.
And where did Herndon come from?
Herndon was one of the first cases regarding Miranda in 1974.
When you say one of the first cases regarding Miranda,
It was one of the first cases that looked at Miranda and outlined how exactly to determine custody, since it's an interesting mixture of fact and law.
what court did it come from?
It came from a federal court.
Herndon did?
No, Herndon came from a California court.
And where did Craighead come from?
Craighead is a U.S. Supreme Court case.
Are you sure it's Supreme Court? Or is it a federal circuit court?
It's a federal circuit court, but it's Ninth Circuit, which means that it covers California, so it is law here.
Okay. We'll get back to that in a half second. All right, so totality of the circumstances, what does that mean?
The totality of circumstances in which is a test in which no pieces of evidence are positive, but rather all are taken into account.
For example?
For example, you can use factors such as whether objects indicative of arrest are present, how many police officers there are, maybe even the age of the suspect.
All right, so in this case, your client, what do I take into consideration? What do you consider to be the totality of the circumstances such that I would grant your motion?
Well, you have to consider that it's very late at night, and she is isolated, being what she had no contact to any family members or friends. She's also alone in a police car with another officer, and these officers have already shown her that she is never told that she is free to leave. The officer said, You can either go sit in the car and talk to me, or you can stay out here in the cold and you can talk to me. And nowhere in that is you can leave and then go talk to me later. You can go in the house and warm up.
Is that a prerequisite under the law? Does officers have to say you can leave?
No, but by saying it's part of the statement. It's not part of the law, but it's a factor you must look at to consider how the tone of the interrogation is set.
And what case that you have specifically looks at whether the individual is free to leave or not?
Well, no particular case addresses that fact, but many cases offer it as part of a test.
Give me one case that you're thinking of.
U.S. versus Craigie offers whether the suspect is told that they are free to leave.
What about in Green? What are the facts in Green?
Green is a man, the fact situation in Green or the holding Green?
Fact situation.
The fact situation in Green is a man is in his house, and the police come up and they lead him into a room, and they lock the room, and then they continue to interrogate him, and then they interrogate him, and then they leave, and then there's a second interrogation after a short period.
And where's that interrogation?
The interrogation is in the same room.
Okay. And what does Green stand for? What's the law that comes out of Green?
Green says that notwithstanding the lock on the door, that as far as I can recall, I don't remember the law that comes out of Green.
Well,
But I do remember the holding, what they said about the fact situation. Would that be sufficient?
that's actually the law.
Okay.
So that'll work.
For the first interrogation, it was not custodial because notwithstanding the lock on the door. So even though there was a lock on the door, it doesn't matter. It wasn't how the circumstances wasn't enough.
So how does that fit in your case?
Well, there was a lock on the door, but similar to Green. But there are also other factors in the case that make it so it was a custodial interrogation, such as it was the middle of the night. She's a high school student alone with a police officer, with another police officer of a physically intimidating presence, is a mere few feet away.
But she's also an adult. She's not a minor.
18 years old. If it was like just 2 weeks ago, she would have been a minor. 18 is not a magical age. You have to consider that she has been 18.
I beg to differ with you. 18 is fairly magical under the law. When you turn 18, you are an adult in the eyes of the law, which means you can go to state prison. If you're under 18, you only can go to juvenile detention. So it is a magical number.
It's a magical
So
number.
let's not.
We have to consider that she may have not come to terms yet with the fact that she's 18 and she is still in high school.
I'd like to consider that as a totality of circumstances that Ms. Vega hasn't come to terms with that she's 18 and she's now considered an adult in the
Yeah.
eyes of society.
And she's also still in high school.
Well, there's a lot of 18-year-olds that are in high school.
So it's part of the fact situation that you have to consider. You have to look at her as a reasonable person, would she feel in those circumstances.
So you indicated reasonable person. So you said you need to look at a reasonable person to see how she feels. So what type of test is it?
It's both. You have to combine the totality of circumstances test with a reasonable person test. You have
So
to look at the totality of circumstances. Oh, sorry.
No, I don't collect songs. Does the totality of circumstances, is that a subjective test? Does that mean that I look into the mind of your client? Is that what you're suggesting?
I believe the totality of circumstances is an objective test.
Okay. And if that's an objective test, what is the reasonable prudent person? Is that an objective or subjective test?
The reasonable person test is a subjective test.
Is it what?
Is an objective test
There you
because
go.
you're looking at.
A reasonable prudent person. All right. So then do I care about what her thoughts are, your client's thoughts?
Not an objective test.
Okay. So you're asking me to suppress her statement because of what reason? What legal reason are you asking me to suppress your client's statements?
Because she was in custody and not read her Miranda rights.
Why was she in custody?
Because her fact situation fulfills the police dominated test as
Okay.
outlined.
All right. You have that down, and that's a conclusion, and that doesn't help me at all.
Okay.
Okay? I
Because
need to know the facts. Why is she in custody?
she's in custody because she was in a cage, basically in the back of the cage car. The police officers interrogated her because her interview, she was